Okay, thanks. Well, good afternoon, everybody, and thank you for joining us today. As we all know, we're in this very different and uncertain times and an unprecedented situation where we're all using our home internet and broadbands and hoping it's all working. So it may be that yours isn't as stable as demand builds. So with this in mind, during the webinar, we are going to have the microphones and videos turned off. But if you want to submit a question, we do have a Q&A function. That'll be on the right of your screen. And if we've got some time at the end, we'll look to answer as many of those questions as we can. If they're not all covered, then we will respond to you after the session. And the other thing, I'm completely rubbish with technological stuff, but if you do encounter any audio issues during the webinar, then I'm told that an alternative option is to join it by phone, and that you should have had those details on your joining instructions email. As you can see, I'm not Holly. Holly Meeville-Hawkins sadly was taken poorly today and she had to have a COVID test, so we're hoping that she's going to be fine. My name is Patricia Wass. I'm a member of the mental capacity team of Enable Law, and I specialise in court protection work. I've been a panel deputy and I've been doing this 38 years now, so hopefully know something about what we're going to be talking about today. The title of the seminar is Tax Planning in the Court of Protection. Just to make sure that we've got the basic principles, we go back to our Section 1 principles, that everyone is deemed to have capacity unless it's proved otherwise, that we support people with their decision making, that we use least restrictive options, that they can make unwise decisions, and that the best interests principle, which we'll be looking at in more detail, that's an important part of those basic principles as well. So just at the back of your minds to have those Section 1 principles there, and then the Section 2 and Section 3 principles, the diagnostic tests and the functional tests around mental capacity generally. So there's no single approach to gifts that apply to every deputy and attorney. As we know, decisions in the Court of Protection are time specific and decision specific. So just because somebody can make a decision today, they may not be in a position to make that decision tomorrow or next week if they have fluctuating capacity. And there are always issues, aren't there, about making sure people are making those decisions at the best time of the day. So if somebody is better in the morning, then that's a time when we should be speaking to them. And just to be aware of medications and all those sorts of things, so that we get we're able to speak to our clients at that best possible moment for them, so that we can help and support them make those decisions so far as they possibly can. So attorneys and deputies have to make decision making considering the context and the timing. And as I said right at the beginning, the best interest, this is really important, that one of the main considerations is whether the specific gift or planning is in that person's best interests. For those of you who aren't legal practitioners, the Office of the Public Guardian has some very, very good practice notes. And there is a very good note on gifting, which is quite recent. And there's an excellent summary there of what gifting and IHT planning attorneys and deputies are able to embark on. So I would refer you to that. So the other principle that's a very important one when we're looking at decision making is Section 4, and this is around sort of the best interests really, and what other things we should be taking into consideration. So it's very important that we don't categorize P into any particular category or make presumptions based on that person's age or appearance. we should think about their past and present wishes and feelings, if there were any written down. So if there was perhaps a previous will or something like that, where they've made their feelings known and obviously their wishes and their beliefs and other factors that they might have considered in respect of the decision that they're now being asked to make. And also, it's important to take into account the views of those that are close to the person concerned. So the deputy or the attorney, there may be carers, there may be friends, family, relatives, people that have an everyday presence in that person's life. It's important that they're taken into consideration as well, because they may be able to bring something to the party that is helpful and that the court will be able to consider when making a decision. The balance sheet approach is something that has happened in some of the cases where the judges have looked on balance whether things are in the person's best interests. So they'll look to the positives and the negatives and see if on balance that the decision is going towards perhaps a positive decision. And the other thing that isn't mentioned on the slide, but the court will also look at whether there are factors of what we call magnetic importance. So there may be a particular factor that overrides everything else, and therefore that is really important, and that magnetic factor could be something that can make or break a decision and a case going forward. And as the last point on that slide says, that it has to be at least restrictive as possible. That is one of the Section 1 principles. In terms of gifting, we do have statutory guidance now in Section 12 of the Act. So Section 12.2 sets out guidance as to what gifting is acceptable by attorney. So if an attorney wants to make a gift from P's resources, then it sets out that those gifts can be made on customary occasions, and we'll look at that in a moment, to those who are related to or connected with the donor, to any charity to whom the donor made or might have been expected to make gifts, and that the gift isn't unreasonable having regard to all the circumstances, and in particular in respect of the size of the donor's estate. And some of the cases make that very clear, which we'll look at a moment. Deputies have very similar guidance, but obviously they are absolutely tied to what is in their order. So it's very, very important that if you're acting as a deputy, you look at your order on a regular basis and make sure that what you're doing for P is something that you have authority to do within the order. And if you don't, if there's any doubt, then you should be going back to the court for express authority. In terms of how it applies to IHT planning, unless there's express authority in an order for a deputy, then you really can't be giving gifts unless they are for a customary occasion, and that gift, as I said, is reasonable in light of that person's estate. So when you're looking at what's reasonable, you have to look at what is considered reasonable when you look at the person's particular financial situation. So you look at things like their current and their future income. You have to look at their assets, their liabilities, their capital, their savings, but also what their present needs are, and as well, importantly, perhaps for elderly folk, what their future care needs may be. So all of that has to be taken in the round. And then you must look at whether their income covers that spending and will be able to continue to support them in the future. And if you make a substantial gift, whether that is going to really affect their standard of living and their lifestyle, because if so, that's something that you really need to be thinking about before making a gift from that person's estate. And obviously best interests, and we're going to look at best interests within the cases, because the arguments for and against do come through some of the cases. In 2013, we had a whole host of cases. This was affectionately referred to in the profession as the handbag case. We had the reptile case before, which for those of you who may recall was the case of an aunt and a niece, where the niece was attorney for her aunt and thought that it was preferable for her to have a gift from her aunt's estate to invest in a reptile breeding business, which was going to give her a 20% return over 2 years. And unsurprisingly, the court was very cross about that. It was looked into, the court's awareness was that they were made aware of it, and that attorney was sacked for what they'd done. And this was the GM case. This was the case of Gladys Meek, and this was affectionately referred to as the handbag case, because these two deputies were going off buying expensive handbags, watches, laptops. They even bought themselves cars with the resources, and the court was very cross with them. And but what the case did do was set out some clear guidance as to what we should be looking at when looking at gifts. So in terms of, sorry, excuse me, just got a bit of hay fever today. When looking at the sort of de minimis exemptions, we look to see whether the value of the nil rate band, whether the estate is worth at least that, and also whether P has a life expectancy of less than 5 years. We look to see whether the gifts are affordable, taking into account the person's care costs for an elderly person, perhaps, and doesn't affect their lifestyle, and that there is no evidence in the wishes and beliefs and values that the person would have opposed those gifts being made if they had a capacity to make them for themselves. You're able, if you have an estate in excess of that, to think about the annual inheritance tax exemption of £3,000. The court will not object to you making an annual gift as long as the estate is worth more than that in terms of money. And then the annual small gifts exemption of £250 per person, up to the maximum of, say, 10 people. As we know, that is an exemption we can have from HMRC, and that can be used as well. So just looking at a couple of the cases where we've had inheritance tax planning looked at by the court. This quite recent case, the 2018 case here, PBC and JMA, is one that was quite interesting to see what the court looked at. So this was a lady who was born on the 15th of December 1945. Sadly, she had early onset dementia. She required full-time care, and she was being privately funded in her care home. She had limited capacity, and there was no dispute she wouldn't have capacity around making gifts. And the life expectancy was between 3 and 5 years, and she herself had 1 child and 1 grandchild, and she'd been married 4 times, and the wealth, which, as you can see on this slide, was substantial. It was about 18.5 million. That came mainly from her late 4th husband, R.A., who had sold a business and had substantial assets from that. The family, both her and her husband, had a lifetime history of charitable and family gifting. And when her husband had been alive, they'd both taken specific lifetime tax planning advice. And she'd also taken advice when she had capacity around tax planning and what she could do to look at that in her lifetime. Now, that was lifetime tax planning rather than particularly IHT planning, but she had sought tax planning advice. So because she had such substantial wealth, this quite short life expectancy, she was never going to need a lot of this money for her own needs. An application was agreed between the parties that there should be a gift of £6 million made to her son, who was the applicant, some gifts to the charities who'd been named in her previous will, and one actually to the Alzheimer's Society as well. And then that there be a fairly substantial gift into the trustees of discretionary settlement, under which her grandson would be the primary beneficiary, and that because there would be IHT on that as a lifetime gift over the amount of £325,000, that should be paid from her estate, and various further gifts of certain chattels. And that would represent some significant tax savings of potentially up to 3.2 million, obviously, should she survive 7 years and all of this fall outside her estate. So it would have a significant effect on her estate. But as I said, she had more than sufficient funds to support her for the rest of her lifetime. So what did the court do? They wanted to really know for whose benefit this was. You know, were the proposed gifts for her benefit? Were they in accordance with her past and present wishes, feelings, values, beliefs, including the tax planning aspects and the previous gifts that she'd given during her lifetime before she lost capacity? and whether the proper consideration had been given to the expression of a wish in the will of her late husband. Now, that was in respect of him wanting to consider his own children from his previous marriage as part of the sort of bounty of her gifts, that they would be taken into consideration in any gifting that went on. So they looked at her best interests in some depth, and what they said was that best interests were not synonymous with self-interests, where people were making applications because it would suit them quite well, that they would benefit, in whose best interest was this? And that, we had to balance the best interests and looking at the self-interests argument. So the case looked at section 4, which are around the factors that would be taken into consideration. And part of that in section 4.6 was around whether the factors could include the effect of the decision on other people, the obligations to dependents, so here her son and her grandson and the children of her husband, and the duties of a responsible citizen. And there was an earlier case there, which I'm not going to go through, but that was around best interests and where maintenance was being looked at by P in that previous case. So what the court did, they concluded that she hadn't really had, that there was no presumption in favour of tax planning, and that the IHG planning weren't of any favour to her. That I think should be JMA rather than PMA, but they would benefit her family, and that was a positive factor because she would probably want to provide for them and had done in her lifetime and would probably want to continue to do so should she have the capacity to be able to do that. Affordability was something that should be taken into consideration, but it wasn't the only condition that was necessary in thinking about making those lifetime gifts. So the reason that the court did allow this application to go ahead and said that it was in her best interests was because everyone involved with the case were in agreement. There was no sort of people saying that they didn't agree with what was going on. There had been that clear history of gifting to those who were set to benefit. Her late husband's will had been clear that she could consider benefiting the charities that were now going to benefit. So that was something she was likely to take into account. And what was important that she had, and which we'll see contrasted in another case, was she had had this history already of seeking tax planning advice. These gifts were more than affordable to her. And her son had been appointed as her attorney, and therefore there was this sort of element of trust in him making this application. In that case, the court did accept, and they structured that lifetime sort of gifting in the way that had been applied for. They did say that could go ahead. So now if we contrast this case of MJL and FL, so this was a gentleman who was in his mid-50s. He sadly had a severe heart attack, and it left him in a permanent or persistent permanent vegetative state. And FL, one of his brothers, was his sole deputy for property and financial affairs. MJL had 4 other siblings, and what was quite important was that they were all wealthy. They all had very substantial wealth, and his estate on its own was very significant and stood at around £17 million. Because of his persistent vegetative state, the care funding was being met by the NHS. He had continuing healthcare, so had very little outgoings, and whereby his income coming in from his investments was around £120,000, his outgoings were only about £16,000. And the medical evidence that there were no particularly accurate life expectancy predictions. During his lifetime, before he lost capacity, he'd had some sort of left-leaning, sort of Labour-leaning sort of tendencies. He'd made regular gifts to left-leaning organisations and charities. And he'd also asked that his entitlement under a separate family trust, which was itself valued at over 2 million, be directed to those in need. So quite philanthropic, but as I said, quite left-leaning in his tendencies. there had been a statutory will made for him back in 2010, and in that 40% of his estate had been left to charity, and then the remaining amount had been bequeathed to friends and family members. During sort of, looking at his capacity before he'd, been unable to make decisions, he sort of had minimum awareness of tax. He hadn't done any tax planning. He hadn't really accepted his wealth. He lived a very very meager sort of lifestyle. It wasn't excessive, and therefore that was something that the court would take into account when they were looking at their decision in this matter. So what FL did, he asked for ratification of the very modest past gifts made from income to charities and family members, and permission to make some significant gifts to charities and family members from both income and capital. So what they looked at in terms of best interest criteria here was the fact that, as I said, he hadn't engaged in tax planning, but the funds wouldn't have any material effect on his wealth or his lifestyle of the siblings if they were or they weren't made. They were already very wealthy. He'd struggled with his own wealth, lived very modestly, and therefore benefiting siblings was probably not going to be a major factor. They were far in excess of anything that he'd done previously. There was the charitable giving, so that would support gifts of charity on an ongoing basis. And his left-leaning principles wouldn't necessarily prevented him from considering tax planning, but he probably wouldn't have done any sort of aggressive type of tax planning. And the charities were also going to benefit under his will as well, so they didn't particularly need the cash now. They weren't startups. So in this matter, the court authorised the past gifts were ratified, and because actually they were quite small gifts anyway, they came within that de minimis exemption of less than 3,000 a year or up to the maximum amount. So they weren't breaching anything in any respect. And there was also going to be an immediate gift of £1,184.387. That was done as an accrual of his surplus income that was calculated. But they didn't authorise capital payments, which was quite interesting. I suppose one of the other IHT exemptions we have in lifetime is to use the normal expenditure out of income. So if you have an excess income, you can make expenditure from it free of inheritance tax. So I think the court took that into consideration. And because he'd set up direct debits in his bank account, the ongoing payments to the Labour Party Red Banner and Charter 88, they were all allowed. So the principles taken from that case where basically when they're looking at gifting, affordability is necessary but not sufficient as a main consideration, that there would be no default position regarding wanting to benefit family members and tax planning. But looking at his approach in lifetime, his approach to charities, that was important in this particular case. And as I said, the court were more willing to accept the gifts from surplus income rather than capital. And looking at the statutory will, very important, and gifting, looking at any will provisions would be taken into consideration. So just as a contrast to this is an earlier case that Senior Judge Lush looked at back in 2012, which was JDS, which all of you may be familiar with. This was around a settlement that had been made. So this was court damages that had been given to this young man. He was 21 when this application was made. He had a limited life expectation, and he had achieved just over £2 million at the time of his hearing from a clinical negligence award. He was getting high level of care from his parents, but not spending all of the income, and therefore there was a surplus, and an application was made by the professional deputy for a trust to be set up for £325,000, which would have been the nil rate amount, which wouldn't have attracted any inheritance tax, as a sort of tax planning application. The OS didn't like that. They said that it wouldn't be in his best interests. And what the court said here was that when the settlement had been sorted out for him, this wasn't anything to do with tax planning. This had been looking at his care, his future needs, his care needs, his requirements, his therapies, and therefore, if the deputy had done his or her job properly, then on the last day of his life, he should be in the process of spending the last pound of that head of damages. There shouldn't really be anything left over. So that the court said here it wasn't their function to ring fence or maximise inheritance for benefit of family members, because that wasn't the purpose of the compensation for which the personal injury was intended. As an aside, if that young gentleman or somebody done a lottery ticket for him and he'd come up on the lottery, that wouldn't mean that a further application couldn't be made. But in terms of his settlement and for the damages for his clean neg award, that shouldn't be used for sort of inheritance tax planning. And the last case, just before I hand my part of this over, is the matter of PEP. This was quite interesting, and for our financial advisors listening, this was around some octopus investments that were set up for an elderly lady. She had an estate worth just over £1 million. She had 2 attorneys, her professional solicitor and her son-in-law, and P, when she had capacity, had avoided IHT planning. She'd had a rift, sadly, with her daughter. That was the attorney's wife, and the daughter was still the primary beneficiary of the estate. There was a real sort of conflict here because the son-in-law was making significant gifts of property and money to his wife, the daughter, and he also invested a significant portion of her remaining estate in one of the Octopus BPR, the Business Property Relief Schemes. And for those of you who aren't familiar with this, my understanding is that as long as the scheme is set up and P lives for 2 years, then business property relief will apply and those investments will fall out of the estate for inheritance tax purposes. So it's pretty damning here. The court said that BB didn't act in PP's best interest in instructing the financial advisor to make investments whose primary purpose was, in this case, for the saving of IHT and the use of the BPR relief. And the court said, and I think we can probably see it, the benefit of hindsight is a wonderful thing, that BB had a conflict of interest. He was married to the main beneficiary of the estate, so he may indirectly benefit from his wife's a bounty from her mother. And therefore, there was a conflict, and they needed to think about that when looking whether this was in P's best interests. So the judgment said it wasn't in her best interests to have the IFA look at the investments whose primary purpose was for the saving of IHT, and that conflict was looked at. And what the court said, and which is very important, is if there is any conflict of interest, then court authority must be sought. And where the primary purpose of financial planning is to save IHT, and it's unclear what that benefit to P is and how it can be in that person's best interests, then that needs to be looked at carefully and an application may be required, because the person that's really going to benefit from this is the person who is the beneficiary of the estate rather than P, his or herself, other than being remembered well and, you know, doing the right thing for family. That's not to say that isn't a factor, but it's not perhaps the only factor that should be considered when looking at all of this in the round. So if there is an investment strategy which is sort of quite high risk, which I think the octopus investments can be, then that is of concern to the court. So just to finish, and before I pass on, we are ourselves as a practice having to make a number of applications for gifting, sometimes where gifts have been made by family, particularly family members, over and above what perhaps should have been looked at before we've picked it up, either as a panel case or because the attorney or deputy has been concerned by what they've been doing, or it's come to mind in some other way. So just to refresh, attorneys and deputies have very limited gifting. IHT planning can be looked at, but only in very limited circumstances. And if in doubt, you should always pass on to the court. If there's any doubt at all, it's always as well to make that application. It's worth it, even if the courts say, no, you've got the authority. I would much rather, in my own experience, have the court say that to me than be picked up for something that is then reported to the court and you found that you've acted beyond your authority. So look at that gifting guidance that the OPG have produced. Look at some of those cases, that JM and case, the GM, the Gladys Meek case, the 2013 case sets out some clear guidance. And for deputies, check your authority, keep checking, and please do make those court applications where you need to. So I'm now going to pass on to Gareth Lewis from Tilney, who is going to deal with his part of the presentation.
Well, good afternoon, everyone, and thank you very much, Patricia. Firstly, my apologies that I'm a disembodied voice on this call, but my upload speeds from a hill in Wales are not fast enough to support video as well as voice. So in order to keep the audio quality as high as we can, it'll just be me and some slides. As I say, there are a few slides, but these are not things I'm going to talk through in any great detail. These are more aid memoirs to me as I talk and some points of interest for you. The purpose of what I'm going to talk about is to give a high-level perspective on COVID-19 and the longer-term implications for investment markets that devolve from the virus. And in the presentation, I'll talk briefly about some observations about the virus and the risks that we face in placing excessive reliance on infection and mortality rates. I'll reflect a little bit on the initial market reaction in March and highlight two very important, I believe, conclusions from that. And then by drawing some parallels with the global financial crisis, help to suggest some reasons why the markets have recovered in the last 2 months, despite the poor economic outlook, and then finish off with some longer term investment considerations that I think we all need to be cognizant of as this situation evolves. So as you can see on the slide in front of you, this is just some background with regard to the magnitude of the falls that we experienced in March. And I think it's worth just recapping on that briefly. So during March, we saw equity indices moving by 5% plus on a regular occasion, a regular occurrence, often in equal and opposite directions. Market circuit breakers were deployed, particularly in the US, to prevent further falls. The US Federal Reserve was required to inject significant liquidity into the US Treasury market, which is the deepest market in the world. And peak to trough, the S&P 500 fell by very nearly 28%. Despite this, only one global market closed, which was the Philippines, and price discovery, generally speaking, remained possible in most markets, albeit with very reduced levels of liquidity. But it wasn't really the size of the falls that were remarkable in March. If you look on the slide to the left-hand side, the magnitude of past bear markets exceeds this. It was with speed with which the falls occurred that was quite remarkable. And in this, we need to sort of understand why that happened. And I think there is a risk in ascribing all of this purely to the virus itself and the COVID-19 pandemic. And I think if you look at the speed of the declines as well as the magnitude, we need a slightly more complex explanation. And in trying to understand these reasons, we'll get a better idea of perhaps what's going to happen next. And I think it's important when you think about the virus to understand that we really do still not know a great deal about the infection rates, the mortality rates that are devolving from this. We probably won't have a full picture of the magnitude of the problem we're going through for several years until test results come through. And it's dangerous to extrapolate too much of the current published data and draw long-term conclusions, because testing regimes vary hugely from country to country, as we know, that some of the tests are more accurate than others. And we simply are not developing enough understanding around issues around herd immunity and the ability by which we have to protect ourselves from this. And in that context, it's very difficult to draw economic conclusions in the long run. And in fact, if you actually look at the only data sets that probably have been produced in near laboratory conditions, which were the cruise ship Diamond Princess, which was quarantined early on in the crisis, and there was a small Italian market town called Vaux that went through a complete quarantine event. And from this, it appears as though, although infection rates from COVID-19 are higher than standard flu, the mortality rates are actually not significantly greater. They're about 0.3%, not the 1 to 2% that has often been reported in the press. And it's also interesting to note that some of the data that's been coming out of Italy very recently is showing that the mortality rates in the sub 80-year-old age group with no comorbidities is actually well under 1%. Now, this is not in any way meant to underestimate the humanitarian consequence of what's happened, but it is to attempt to put some context around recent events. So if we actually then try and reach an explanation for what drove this, I think there are two things that we need to bear in mind. The first one, and it may appear obvious now, but I think is still very relevant, is that investors and markets responded not to the spread of the virus, but to actually the policy response to that virus. So effectively, the markets were falling and reached a bottom at the point when we reached peak response rather than peak infection rates. And when I mean response, I mean not just the lockdowns and the curfews and the travel bans. I actually mean the monetary and the fiscal stimulus. And if you look at the coalescence of those events, really it was the American government who were the last to fully recognise the threat posed by COVID-19, and the lockdowns that they initiated towards the end of March actually coincided with Federal Reserve monetary policy and significant fiscal spend from global governments, which allowed markets to form a bottom. And in this, I think there are some lessons to be learnt from the global financial crisis. If you look back to when Lehman's failed in September 2008, global asset prices continued to fall for nearly 6 months from that date, despite interest rates being cut, the initiation of asset purchase programs, repeated capital injections into the bank. The reason the markets turned is all to do with psychology. Human beings have a tendency to conflate action with understanding. So they actually are looking for a response to an event, even if the event is not properly understood. And what actually triggered the market rebound in March 2009 was the sheer magnitude of the policy response that the banking crisis elicited from central banks. And in this, there are direct parallels with what's happening at the moment. The markets turned not because we have this situation under control, but because the response that we received was of such magnitude that it allowed investors to believe that people had some control over the situation and that events would improve going forward. The second explanation, which is linked to this, is market positioning going into March. So if you look back, we've had an 11-year bull market almost uninterrupted, where we've seen significant central bank action to support risk assets as and when we've had any sell-off events at all. And this has allowed investors to have a sort of Pavlovian response to bad news. Bad news means more stimulus, means asset prices go up. And when we went into the COVID crisis, that meant that an awful lot of investors were carrying quite high-risk investment strategies, often highly levered. And when COVID-19 hit, in the very short term, it became clear that even Federal Reserve response would not prevent the global spread of a pandemic across borders. And this so-called black swan event led a lot of investors to need to raise liquidity quickly. As asset prices fell, margin calls on the levered positions increased, and investors were forced to raise liquidity from any asset that they could find. And this is why it wasn't just equities that fell during March. It was bonds, actually gold, all the things you would expect to diversify a portfolio were also susceptible to sharp volatility and falls because of this need to raise liquidity. And the issue about liquidity and the issue about policy responses sort of coincided, completely coincidentally, with the March US futures and options expiry on the 16th. And that was the point after which things started to improve. As people got through the requirement to raise liquidity for op margin calls, the market was in a position where it could actually recover. Now, in terms of market recoveries, we believe the market is going to go through a sort of three-phase approach to this. The first one, which is the one I think we've already now been through, is the sort of indiscriminate sell-off, which is not driven by rational economic assessments of the long-term prospects, simply because we simply don't know what the long-term prospects are. It's driven by liquidity issues, it's driven by margin calls, it's not driven by long-term economic modelling. And in this phase, what we saw was significant falls across a whole range of sectors. The slide in front of you simply shows the falls through March. This is not peak to trough. The market's actually troughed about a week before this data was cut, but it gives you an idea of the magnitude of the falls by sector in the S&P 500. And the second phase is a reaction to this, and it's the second phase that I believe we're in now. And the second phase is being driven by this belief that central banks and governments have got investors' backs and going to support not just the economies, but risk assets. And this is where investors are trying to buy the more bombed out, the companies that have fallen most. They're trying to capture market beta. They're buying the things that have fallen. And if you look at market leadership over the last month, it's largely been led by those sectors at the bottom of that chart that fell most through March. Now, this second phase to us is potentially the most dangerous because it gives some semblance of normality. Equity markets are rising. People believe we're past the worst of this. But it's a perception that is actually, in our view, quite thin when you look at the underlying fundamentals. And people who are tempted into markets to buy market beta, to buy the bombed out stocks, are actually taking, in our view, quite dangerous investment decisions that actually we are still a long way from understanding the economic consequences. And it's quite important that people recognise that many companies, in our view, will fail completely as a result of what's happening. And that the key thing you need to be doing is focusing on the quality of what you own, not just the fact that the share price has fallen a long way and therefore has a long way to recover. And in this, we would caution against focusing too much attention on index levels and aggregate earnings. Aggregates, obviously, an amalgam of many companies, both good and bad. Indices are the same, and they can give very misleading ideas of what's going on. You need to focus on quality, and you need to focus on what will survive this crisis, not just recover in the short term. And then the final phase is the one where I think a lot of the sort of pigeons come home to roost, in the sense that what you'll see is a lot of the companies that have rallied quite strongly in terms of share price movement recently will be met by further selling. You will see investors start to recognise that some companies can and will fail despite central bank action to prevent that. And then investors will become considerably more discriminatory in their decision making, and they'll be focusing on cash flow and the ability to return that cash flow back to shareholders through growing dividends rather than just capturing market beta. And then this is the phase where you will start to see default rates rise, and you'll start to see real market leadership being shown by the better quality businesses. Now, that third phase may not really take place until towards the end of this year or early next. I think this second phase that I mentioned earlier is really quite protracted and could last for some time. So if we now look at markets and where we are and what's likely to happen next. So our view at the moment, we're in this market's second phase. Attention will focus partly now on infection rates and hospitalizations to see if the easing of lockdowns will create reinfections. And one of the big short-term threats to the recent market rally is that the rush to ease the lockdowns as R rates drop below 1 could lead to higher infection rates and further lockdowns. Because investors are trying to look through the trough in the economy, and they're trying to understand when the recovery in economic conditions will improve. But until they get a real sense that recovery is real and tangible, you need to understand that markets can continue to trade higher, not driven by economics and not driven by fundamental earnings, but driven by the link to the continued faith in the authorities that the situation will continue to be supported by central bank action. And in this, we think it's unlikely that the markets will retest their March lows unless you get a significant increase in reinfections. There are, however, some short-term issues that might impact the recent rally. One is we are about to enter the run-up to the next quarterly futures and options expiry, and we could see some of the open market positions unwind through that. The global relationship between the US and many of its key trading partners is deteriorating as Trump sort of lashes out against external threats in his attempt to increase his domestic popularity. And I think a deterioration there could have significant longer-term implications. And there's even the ongoing constitutional challenges to the legality of the ECB's QE activities in Europe, which could threaten the recent rally. If we now look at the economic consequences, one of the things that's featured very largely in people's debates is the massive increase in unemployment that's taken place. The slide that I'm just showing you now shows you the massive increase in the unemployment rate in the US. Over 30 million people filing for unemployment in 6 weeks. We did get a slight improvement in that trend at the end of last week, but nevertheless, the numbers are absolutely huge. And this has given rise to the general perception that what we're experiencing is a demand shock to the global economy. That if you take 30 million US workers out of the system, the demand from the consumer has to collapse. And I think that's slightly misunderstanding what's happening here. Because if you make the rash assumption that every one of these workers is not just a demand within the economy, if they're pursuing some sort of economically valuable activity, they're also a supply in the economy as well. And that the two things, while they may not be equal and opposite, are offsetting each other to a certain extent. So you're not just taking demand, you're taking supply out of the system through the redundancies. The other thing to bear in mind in the short term is that governments are very much focused on protecting the consumer through the furlough and the payment protection plans. Now, while they may not last in perpetuity, governments are sending out a clear message that they're looking to protect the wider population impacted by lockdowns. And this is one of the reasons why the savings rates are rising quite quickly in the developed world. It remains to be seen whether any of those savings are released as lockdowns actually ease, because we don't know yet how many people will be re-employed. But I think it's wrong to think of this as just a demand shock. There is a significant supply reaction here, and there's a natural tendency for policymakers to protect the consumer in all of this. And if you look at this in the wider context of policy responses, faced with a choice between allowing the system to clear in the sense of corporate defaults and bankruptcies, which will create permanent long-term unemployment, both governments and central banks are clearly going to focus on ever greater monetary and fiscal support to prevent that from happening. And that to us means that we're entering a period, the first time in human history, where you've got unfettered monetary and fiscal policy acting in unison. Now, if you look back to the period before post-global financial crisis, this was largely monetary response rather than fiscal response that we saw. And just to put the size of this response into context, the slide I'm showing you now shows you what the Federal Reserve have done to their balance sheet. What you can see is that the Federal Reserve's balance sheet doubled from Lehman's failing to the COVID-19 event. It went from $2 to $4.5 trillion over a 9 or 10 year period. It's projected to double again to 9 trillion in 8 months. Now, this is absolutely remarkable. And the fact that the Federal Reserve are intervening and buying high yield bonds through their QE program, not just treasuries, is sending a clear signal to investors that risk assets and equity markets are now too important to the global financial system to be allowed to collapse, and that central banks will do whatever is required to support asset prices while we go through this COVID-19 crisis. And you know, this creates huge moral hazard in the longer run, because you're effectively socializing the losses on the government's balance sheet, but privatising the gains. And I think that is unsustainable in the medium term. In the words of Deutsche Bank, and investment bankers love using sort of an awful lot of slang expressions, but the Federal Reserve have, quote, loaded the bazooka with a kitchen sink and gone nuclear. And that's just a way of trying to express the magnitude of the response. And the other thing to bear in mind is that a lot of this response is actually going to be delivered to the economies through government spending. That this is actually passing the spending baton from central banks and the private sector to the public sector. And governments given access to unprecedented fiscal largesse are going to run economies hot, or try and run economies hot, in the name of social cohesion to prevent unemployment increasing, but really as a way of electioneering. And I think the risk of this is that this continues for a prolonged period of time, and you actually start to see a melt up in asset prices to protect against inflation. And you actually start to see bond yields rise and possibly triggering corporate default. So if we just pull all of this together, now our current assumptions are that hospitalisation and fatalities across Europe and the developed world have now peaked. Although infection rates could continue to rise as testing regimes improve, we are currently assuming that the COVID-19 pandemic, as we currently understand it, will not be the same economic issue in the future it has already been, that restrictions will be lifted, that although workers will be relatively slow to return to the workforce, if you look at China, it took probably 2 months, but sadly, pollution and congestion rates in China are back to pre-crisis highs, so there's been no long-term impact. That the economics of this mean that you will see maybe not a V-shaped recovery, but a very sharp deterioration in activity in Q2 and into Q3, but that GDP will recover in Q4 of this year into next year, and the IMF data on the slide in front of you shows you that pattern. That equities at their trough had fallen by around 40%, depending on which sectors and which markets. Now, we actually believe the earnings decline is probably 25 to 30%, and that's helped to give some support to the rebound. But we would again sort of caution against focus on index levels and aggregate earnings, because it's the quality of the companies you own that will see you through this crisis. Because if inflation rates start to rise as this fiscal and monetary policy feeds into the system and bond yields increase, then the pressure on weaker businesses with poor balance sheets will intensify, and the risk of default in the bond markets and therefore corporate failure increases. And what you do not want to be doing is owning companies that could fail as you go into 2021 and 2022, because central banks can't prevent, in our view, some form of default cycle occurring as a result of COVID-19. And in a world of unfettered monetary printing, stores of value that protect you against inflation are absolutely crucial. You know, people talk about the value of gold and other precious metals. It will be about using index-linked gilts. It'll be about using equities as inflation protection that help you to put together portfolios that will see you through what is currently happening. So that's me finished for now. I think we're now going to questions. So I'll put my mic on mute, and then we will see what comes in on the investment side or on the quarter protection side. So over to Nikki.
Thank you very much, Gareth, and hello everybody. Tricia, there's a question that's come in for you. In the case that you mentioned of PB v JMA, what about the children of the late husband who didn't seem to be taken account of? Are you there, Tricia? Sorry, everyone. It looks like maybe there's a technical difficulty, but we will get an answer to that question circulated at the end. And a copy of the slides and also a recording of this webinar will also be emailed out, so you will all have that information. So, Gareth, if I can come to you with some questions, please. One that's come in that said, how will the UK and other UK and countries pay bailouts and the special scheme?
So could you repeat that? It broke up a little bit at this end.
Yeah,
sorry, Nikki.
How will the UK and other countries going to pay for the bailouts and other special schemes? Did you get that, Gareth?
I've completely lost sound at this end, I'm afraid.
It's okay, so you didn't catch that? No? Okay, I'll type it. Cool.
Thank you, Nikki. I've seen the question now. It has come through. Well, I think the problem with the bailouts is actually that I don't think there is any clear plan for how these will be paid for. I think that governments in the short term are totally focused on the social consequences of the lockdowns. And I think the risk that governments face is, at the moment, if people believe COVID-19 was a real threat to life, then the lockdowns will appear rational and people will be more acceptant of what's happened. But if, in the benefit of hindsight, the lockdowns have been excessively severe, I think an awful lot of people are going to blame governments for their loss of livelihoods and incomes and the fact that their businesses have failed. And governments are going to be on the hook to perpetuate some of these support mechanisms for a longer period. The only way that this can be financed is by governments issuing more bonds and for the central banks to buy those bonds, which is effectively an increase in the spread of QE. And if bond yields then rise, then the risk is that government debt funding costs increase as well. So I don't think there's any clear plan to come out of this at the moment. I think it's just another incremental increase in the same context that we've seen post the global financial crisis.
Okay, thank you, Gareth. And another question. Can you hear me? Gareth?
Yeah, I can hear you. I can hear you.
Yeah. So owners of capital seem to be doing better than employees. Wages are down, but share prices are up. How sustainable is this?
I think this is a really interesting issue that devolves from this, that the owners of capital have been material beneficiaries under the post-global financial crisis monetary environment. And I think, a lot of the social consequences of that are being played out in global politics, both here and in the US and in other countries. I think the fiscal aspects of this actually do change that, in the sense that governments are not going to focus their ability to spend unfettered fiscal money on the capital owners. They're going to focus on the employees, and they're going to focus on the sort of projects that benefit people's standards of living. I don't think that necessarily means that equity prices don't benefit in the short term from the QE policies that are going on. But I think the risk for asset owners is rising inflation, that actually this fiscal response aimed at Main Street, not Wall Street, the expression is, I think becomes a very material part of the next 5 years. And it's a significant change and break from what's happened in the past. And I think anyone who's making investment decisions looking in the rear mirror is going to be sadly disappointed by what's going to happen next.
Thank you, Gareth. Hi, Tricia. We seem to have lost you earlier. Are you okay?
Yes, I'm back. Yes, I'm back now. Thank you.
Thank
I told you I'm hopeless with the text.
We just had a question about the case that you covered,
Yes.
the PBV and GMA, and they just want to know what about the children of the late husband?
Yes. Yeah. In fact, I looked that up. It wasn't children. It was other relatives. So basically, RA had left a will. This was the husband. He'd made a will in 2005 and left his entire estate to the lady concerned, JMA, provided she survived by 30 days. And in the event that she didn't survive, RA provided in his will that there were pecuniary legacies ranging between 50 and 500,000 to his 2 brothers, his sister, his 6 nieces and nephews, 3 named individuals who'd worked at his company, and legacies ranging between 100 to 500k to each of 6 charities. And what he did, he expressed a wish. So it wasn't an obligation. He expressed a wish that his wife had regard to those residuary provisions, so that if she survived, that she should consider making such similar or lesser gifts as those contained in the residuary provisions as her circumstances allow, and as she thinks fit to those beneficiaries. And then what happened, the lady concerned made an earlier will before this one came to the court, the stat will came to the court back in 2011. And what she did, she spoke to her solicitor, Mr. Morris, about what she had to do. And he advised her that it was only the expression of a wish. It wasn't an obligation. And she'd expressed some displeasure about at least one member of RA's family when she put that will into effect. And he said that she was under no obligation to make those gifts, as it was only an expression of a wish. But what she did do was put all the charities in. So she did take note of her late husband's wishes regarding charities, but not the named individuals.
Brilliant. Thank you for clearing that up, Tricia.
So I hope that answers
Gareth,
the question with what happened.
Yes, it does very clearly. Thank you. And thank you also, Gareth, for answering those questions. That was all the questions that we had. So thank you both very much. The slides and also, as I said, a recording of the webinar will be circulated to everybody. And if anyone has any further questions, please do just follow up. But otherwise, thank you everyone for joining us today.
Yeah, thank you, everyone.
Thank you.